started. Hello everyone, Payal this side. I'm today's your polity mentor, and I'm going to have this demo lecture for you guys. So this was very cumbersome for me to choose which topic to cover for this demo session, and then I finally decided to take over the fundamental rights as a topic to discuss today. When it comes to fundamental rights, first of all, why I chose this topic for this demo session is I believe everyone, even if they are not from UPSC background, they knows what are fundamental rights. And as a citizen of India, we should know what are the fundamental rights. And I believe this is the single topic which I can take over isolatedly without covering the all the topics in a row or a sequence. So as written here, fundamental rights are the souls of the Indian Constitution. And why it is called as the soul of the Indian Constitution? Because being a citizen, being an individual, the very first thing a human being or any individual need is the rights. So either they are natural rights, then maybe fundamental rights, constitutional rights, and so on. But to lead a life which is dignified and meaningful, they need some rights, which we call as fundamental. And these are the rights, these are the group of rights which are fundamental to the existence of the human being. That's why we call them as a fundamental rights. There are some series, or I can say a type of 6 types of fundamental rights given in our constitution. When I say it's given in the constitution, it means all the fundamental rights are constitutional rights, but we cannot say vice versa that all the constitutional rights are fundamental rights, since there are so many articles, you can say, that are there in the constitution, and not all the articles are related with fundamental rights. So in the whole constitution, I can show you, in the whole constitution, there is part 3. To give you some more idea or a brief, the whole constitution is divided into some parts. Like in any book, there are units, chapters inside it, then topic, and so on. Like that, the whole constitution is divided into different parts, and that parts contains a group of articles or a bundle of articles related to particular topic or related to particular, I will say, institution, and so on. This part 3 of the constitution, specifically related with fundamental rights. And here you can see from article 12 to article 35, there are a group of fundamental rights. This part 3 constitute of bunch of articles starting from article 12 to article 35 of the constitutions. And then again, this whole articles can be divided into 6 types that we are going to check later on. So yeah, back to our PPT. As I said, the whole list of fundamental rights, or the whole fundamental rights, are divided into major 6 types or 6 categories, we can say. And they are listed below. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Maybe some of you are already aware about all these rights. Some of you may be completely fresher. So I am not going to really deep dive into the fundamental rights, but my agenda will be more to give you insight what exactly the fundamental rights are, how they are necessary or beneficial for an individual, how they are framed or how they are stated in the constitution, as well as how they are relevant when it comes to your UPSC preparation. So let's discuss in a nutshell. First, right to equality. We always say, like generally girls, when compared to boys, they always say we have a right to equality. Why they say it so? Because it is actually a right to equality, which is given to the constitution, given by the constitution to everybody, every one of us, every citizen of India. So a group of article 14 to article 18 deals with the fundamental rights that are related with right to equality. When we say equality, I give you a scenario. So let's assume there are 2 types of individual. One is healthy, good, rich individual. The other one is, I will say, physically unable, not rich, maybe poor, not able to live his life in a dignified way, and so on. And Now the case is, can we say these two people are equal, or can they say they have a right to equality, or can we compare these two types of individual? So the answer is no, because even though they are a citizen of India, they are individuals, of course, maybe they are of same religion and so on, but we cannot call them equal since they are not equal. So when we say right to equality, it's a really broad concept. It doesn't, I would say, literally covers the meaning of equality, but it also takes into account all the possible scenarios or all the natural, all the principle of natural justice, we can say. How? Let's discuss. So, right to equality, Article 14 to Article 18 of the Constitution deal with the right to equality. And the very first article, Article 14, talks about equality before law. What does that mean? Equality before law. So, you might have seen in courts, there was one statue, which we call as a statue of justice, which is blindfolded. What was the logic behind it? So, the statue of justice, or the, you can say the justice statue, means that it doesn't really matter who were present in the court. For the court, for the justice, it is same. So everyone is same in the in front of law. This is the meaning of equality before law. Equality before law means whether you are rich, whether you are poor, you belong to which religion, you belong to which caste, you belong to which place, that doesn't really matter. What really matters is you, the law, and everyone are equal in front of law. So this is the concept called equality before law. This Article 14 involves two types of concepts. So equality before law and equal protection of law. Equality before law means everyone is equal in front of law. Equal protection of law means law can be different. Law, it is possible that law can be different for the different type of people. When I say different type of people, what does it mean? So we can say there is a positive discrimination. Like before, I have given you one incident or scenario where I have said there is one person who is really well, who is doing well, he is healthy, he is rich, and so on, and the other person who is physically not that able, or he is poor, and we cannot do really comparison between these two people. So when we say equality before law, that's completely fine. They are equal before the law, but the concept of equal protection of law says these two peoples are not same because they are not situated in a similar circumstances, or not they are not similarly placed. So what we have to do, not we, but the state. Article 14 of the Constitution states that it is the responsibility of the state to provide the opportunities for the positive incrimination, for the positive advantages of such kind of individuals who are not equal. We cannot compare these two types of persons. So let's say women's, child, economically weaker section, the people from socioeconomically backward classes. These are all the kinds of people who are, I will say, placed at the down position or not that equal from the historical circumstances, from our historical background, that we can compare these two people at the same time equally. That's why equality before law and the equal protection of law, these two concepts are enshrined within the Article 14 of the Constitution, and that will cover the whole equality, not literally, but in contextually and meaningfully as well. Article 15 of the Constitution says no discrimination. What does that mean, no discrimination? So there cannot be anything which is discriminatory to the other person. For example, let's say there are some grounds mentioned in the Constitution: religion, race, caste, sex, place of birth. These are the 5 grounds that are mentioned in the Constitution, and based on that 5 grounds, you cannot discriminate between the individuals. So let's say if you might have heard about untouchability, the method of untouchability or the historical practice of untouchability, which India used to follow since back, that is now abolished because Constitution given us the fundamental rights. We cannot discriminate among the other individuals on the basis of religion, race, caste, sex, and the place of birth from where they belong. The next article, Article 16, provides equality of opportunity in employment. So what does it mean, equality of opportunity in employment? Because we have so many unemployment as well. So it does not make sure or it does not ensure that everyone will get an employment. What it ensures is, like, whoever you are, from which race, caste, sex, place of birth, descent you are, that doesn't really matter. If it's a government employment, it's a public employment, then everyone has the equal opportunity. Everyone can compete for it. If there are some criteria, some qualifications, some examinations that are necessary to apply for that position, then everybody, it doesn't really matter from which race, caste, sex, place of birth, and the descent they belong. This is the meaning of equality of opportunity in matters of public employment. Why I'm saying so? Historically also in India, women are considered below males, or I will say it is more a patriarchal society. So in order to ensure there should be a equal, I will say a competitive participation of women in every sector as compared to men, what they did, they have given us gender equality. They has given us gender equality, and in order to ensure that gender equality, what Constitution did, Constitution provided the fundamental rights. In that fundamental rights, we say we cannot discriminate even in case of public employment just on the basis of gender. So if you are on the basis of sex, I will say. So if you are woman or men, it doesn't really matter. You have equality of opportunity in matters of public employment. This is what Article 16 says. The next article is Article 17. And if you might know, there are two articles in the Constitution which are considered an offense. So let's say if somebody is there who is not following or who is not practicing or following these fundamental rights, who is not abiding by these fundamental rights, and they are doing against these fundamental rights, this can be considered as offense. So there are two articles mentioned in the fundamental rights which are considered as offense. The first thing is abolition of untouchability. Any person in any format, in any way, in any method, in practicing the method of untouchability, then it is considered as offense. And when I say it is considered as offense, what does it mean? Then it means that this offense is going to be punishable. So this is the meaning of offense. Then untouchability. What is untouchability? I don't know. Constitution doesn't define the meaning of untouchability. There is a separate law, Civil Right Protection Act, and there the word, I would say the definition of untouchability is written there. So untouchability, we even though it is not stated or defined in the Constitution, we know from our experiences, from our past experiences, from our historical background, that this was a practice which Indian used to follow with the people belonging to scheduled caste and basically scheduled tribes, where they have faced many discrimination in the public employments, in public properties, public wells, ghats, and so on. This untouchability practice, which was so ridiculous, now was abolished by this fundamental right called as Article 17 of the Constitution, abolition of untouchability. If anybody practice untouchability in any way, in any format, this is going to be considered as offense, and that offense is going to be punishable by the court, by the law. Next title is abolition of titles. So what are the titles? If you might know, when there were Britishers who used to rule in India, they used to entitle Indians, the Britishers used to entitle Indians with the titles like Raja, not Raja, but Sir, Desai, and Naik, and so Shipai, and so on. This sort of titles they were, and the Raja, who were the mostly the major landowners, landholders of that times, used to assume themselves a title like Raja, Maharaja, and so on. So these are quite ridiculous and discriminatory, because the person who is actually working on the field, the agricultural, the peasants, doesn't have any right of their on their land, and the one who is not working at all and who is hurting or discriminating between these peasants are the one who is considered themselves as landlords, and they are having all the properties and the stake of the properties. So when we got the independence, what we decided by the Constitution, that there will be no more titles that are going to be there by the Constitution, and we abolished the abolition of titles. Now you may assume that when we say he is doctor or doctor, PhD, and so on, and there are military titles also awarded, these are also titles. So this is an exception to the Article 18 of the Constitution, which says the titles which we historically or before the Indian Constitution, before the independence, pre-constitutional titles that are going to be abolished, that are not going to be there no more. But the academic titles, who somebody performed very well in the academic fields or performed very excellent in the academic fields, that are okay, that can be given. So academic and military titles are exception to the abolition of titles, Article 18. What we now just discuss is right to equality. All this article, since Article 14 to Article 18, try to discuss in all the concept of equality, so that nobody can feel themselves, I would say, backward and marginalized. So this is to empower everybody and to have a sense of equality among all. Okay. The next article is right to freedom. But before jumping onto it, I want to go back to the PPT and I can show you something. The second question, why we are discussing the fundamental rights today? There are so many topics there in the Indian Constitution. As I've said, being an Indian citizen, being an individual, you should know the fundamental rights. That's the first and the foremost thing. This is the first reason of choosing the fundamental right as a topic today. The second thing is, if you are aware about the current affairs or the newspapers and the daily things that are going on, you might have heard this day or other day, that some fundamental rights is infringed, or somebody is fighting for their fundamental right, or there is a tussle between the parliament, the government, and the individual based on their fundamental rights, and so on. So this is what I prepared for you guys. Here is a list of all the fundamental rights that are in use in 2025. Maybe there are many more also, but these are the some major highlights of the 2025. So key fundamental rights of 2025 and its highlights. Article 14, Article 15, Article 16, Article 19, Article 21, Article 25, and Article 26. Why I am saying this? As I said before, this is my evaluation based on all the major events, all the major news that happened in this 2025. So we can go through it one by one and take a summary out of it. Article 14, as we just recalled, it's right to equality. It reinforced the protection against caste and gender-based discrimination. It not just reinforce the caste and gender-based discrimination, but it will ensure that nobody can fail inequality. So everybody should be equal in front of law. Everybody should be equal, even in the case of equality before law, equal protection of law. The second thing is Article 15, prohibition of discrimination. We cannot discriminate on the basis of religion, race, caste, sex, and place of birth. Article 16, as we discussed, equality of employment or equality in public employment. We cannot going to discriminate on the basis of religion, race, caste, sex, place of birth, and descent, from where you belong. That doesn't really matter. But yes, if let's say Maharashtra government or Maharashtra state want to employ somebody who are specifically from the Maharashtra and not from MP and Bihar, because you all know that people are migrating from here and there, and then there are overpopulation, and maybe the residential people cannot get the opportunity in their own state to serve the government jobs or the public employment. In that case, that particular state government, for example, the Maharashtra state government, can declare that residence is a condition if you want to apply, or if you want to be enrolled in this public employment, state public employment. So though we cannot discriminate on the basis of residence, but yes, state government can put residence as a condition for the public employment. That is another exception of Article 16. Article 19, freedom of speech and expression. Everybody knows freedom of speech. We have freedom of speech. We can say anything and so on and so on. But that's not true. What Constitution says, you have a freedom of speech. You have a freedom of speech and expression. Definitely, you can say whatever you want. You can express your feeling, but there are reasonable restrictions on it. So you cannot say something that is derogatory to the dignity of the other individual, or that can harm the dignity of the other individual. There are reasonable restrictions put by Article 19, subsection clause 2 of Article 19 itself. Article 19, freedom of speech and expression, balanced with the need to protect the individual dignity. When we say we have a right to life and so on, just living is not a life. So when we are living, we have the health, the good lifestyle, the good standard, good water, good air, and so on. So we need to live a dignified life. If we are living, like people are living in the past days, the scheduled caste people, when they have faced the untouchability, at that time they were living also, but they don't have a dignity. And when it comes to Article 21, right to life and personal liberty, it specifically focuses on the individual dignity and personal liberty of an individual. Just living a life is not a life, or is not a right to life. Rather, living a dignified life is called as a right to life and personal liberty. Article 25 and Article 26, since India is a religious country and we have many religions there, so what Constitution beautifully does is they have provided a list of fundamental rights since from Article 25 to Article 28, who are specifically dealing with the religious rights of the individual, not just the individual, but the religious rights of the institutions as well. So you know there are temples, masjid, and dargah, and so on. So every religious institution as well as religious individual have confirmed and has given the fundamental rights by this Article 25 to 28. And these all rights were in news in 2025. That's why I listed it out here. And what was the basis that I'm telling this is the news we have or the Supreme Court judgment on the recent topics. So the first thing, digital access as a fundamental right. There is a complete list of fundamental rights, and Supreme Court has given their ruling and said digital access as a fundamental right inside the Article 21. So let's assume a case again. There is one individual who is physically challenged, PWD or so on, and we know that there is a digitalization of everything. We are using phone pay, smartphone, so on, everything. Like everything is digitalized now. But is it possible, or I would say, is it practicable for all the individuals who is physically challenged to access the digital market or digital whatever the technologies we have? No, not really. In order to make things accessible to them as well, explicitly Supreme Court said that digital access will be going to be a fundamental right under Article 21 of the Constitution. So all those people who are physically disabled, physically challenged, it's the responsibility of the state, it's the responsibility of the government to make things, the digitalization industry or the digitalized technologies, accessible to them as well, so that they can also feel inclusive. Overall inclusive development will be the goal in the end. The case was Amar Jain versus Union of India 2025. What was the highlight? Supreme Court recognized digital accessibility as a part of Article 21 for a person with disabilities. Supreme Court said it is the necessary requirement for all the digital technologies that needed to be made accessible to all those people who are physically challenged. Directive, what Supreme Court directed to the people, RBI and other institutions must make online system accessible. Example, KYC for visually impaired, who cannot see, who are visually impaired. The digital system should be made accessible to them. And this is one example of it, and which you can see directly related with the fundamental right, Article 21 of the Constitution. The other thing is Ramcharan versus Sukram and others case. This is also a case from 2025 where Supreme Court said tribal women inheritance right. So you might know in India, we are like patriarchal society, and we in our system, son used to inherit the property. So everything belongs to mother and father, everything belongs to the family, is going to be the property of the son by default. But this is sometime back already changed for us people, but for the tribal people, it is still the scenario that the male, or I will say the patriarchal society, dominant over the females there. And then in this case, Ramcharan versus Sukram case, Supreme Court held that tribal woman inheritance right, Article 14, there should be equality. It doesn't really matter because just she is a female, she cannot inherit her property, her family property. And the judgment, equality. Just because she is a woman, you cannot violate her right of inheritance, and that is unlawful, void, and unconstitutional. Custom must align with the Constitution, whatever are the customs. Since you know there are many rules and laws in India, like customary laws, institutional laws, property laws, and so on. Even though these are customs cannot be cannot get the priority over the Constitution or the fundamental rights. And custom has also to be aligned with the Constitution. Custom has also to be followed by the Article 14, fundamental right, and fundamental right is supreme, you can say in this sense. The third case is Jammu and Kashmir police constable torture case. There are many movies and so on where you can see that there are people or the public officials who used to torture the custodians. This is going to come under the Article 21. even though he is going to be within the jail or detained person is there, he has the right to life and dignity. Even he is detained because the crime is not proved. We can say that. So he is not guilty. Ruling, the Supreme Court directed CBI investigation and awarded rupees 50 lakh compensation. So Supreme Court said custodial torture is not at all acceptable. This is going to be unconstitutional void because it's 21 right to life and right to life and personal liberty of an individual. So Supreme Court directed the CBI to do the investigation on this regard. Next case is Professor Ali Khan Mohammadabad bails and gag order. What is gag order? So somebody, when saying something, or when state or anybody wants to restrict the freedom of speech or expression, in that case we call it as a gag order. In this case, Professor Ali Khan was one of the very renowned professor, and he was once attending a live show, a debate, and there in the debate he might have said something that is going to be controversial, and then they put the gag order on him. And Supreme Court said this is going to be a violation of freedom of speech and expression. This is going to violate the Article 19 of the Constitution, and the outcome will be Supreme Court criticized Haryana SIT, Special Investigation Team, and his bail terms defended academic freedom, that everybody has the freedom of speech and expression unless and until it is going to hurt somebody else. So this is again the Article 19, which is in news in 2025. The last one is stand-up comedians joke case. There was many stand-up comedians who in one way or the other are going to criticize the political parties, or some, I would say, not some derogatory words towards women and maybe the lower caste or marginalized section of the society. This is the case regarding that. Balancing dignity and free speech was the agenda of the case. And observation was dignity of individuals, especially from vulnerable section like women, child, physically disadvantaged people, socioeconomically, economically weaker section of the society, can limit the freedom of speech and expression. So yes, you can say anything, but there is a limitation on it. Reasonable restrictions are there. And this is how I came to the conclusion that these are some fundamental rights that were in news this year. Why we are taking so much time to discuss these things, and why it is necessary and important for us as a UPSC aspirant, and how it is going to helpful to us when it comes to exam preparation point of view. So here it is. You can use this, I will say, this kind of approach whenever you are studying for your polity section. For the prelims, match landmark cases with relevant article. So whenever you used to read newspaper or used to cover the current affairs and so on, check there if there is any major use case, or there is any case going on which is related with polity, Indian polity, or which is related to fundamental rights. Check that. That can be useful for your prelims, because we don't know which question can be asked by the examiner, but we can have some idea that, okay, this case is in news, probability this is related with this article, so this article can be asked in the prelims. Mains, court judgments in GS paper 2 essay and essay as well. So GS paper 2 Indian polity essay, you can definitely write there the cases that were in news. Let's say now the dignity topic was in news, that case you can recall and you can just mention it out in the newspaper, in the GS2 paper or in the essay. It will really enhance your answer and it will boost your marks also. For interviewer generally what they used to do, they used to ask you a question which can put you in a dilemma, basically ethical dilemma. Let's say if you are belong to scheduled caste, they will ask you a question which is related with that particular caste, which was also in news, and the expectation was, which is very genuine, that you might have inclined to a specific religion, or maybe you are giving not biased, or maybe you are giving a biased answer in that case. So what you have to do to avoid such a situation, use real world judgments to support your arguments on the legal and ethical dilemmas. Whenever there is such dilemma sort of thing, whenever the interviewer asks a question, I would recommend to answer them whatever the judgments of the Supreme Court. Based on that, and it will save you from all the ethical and legal dilemmas that you are going to face. This is how all this, I will say, analytics, what we have just discussed, going to help you to not to just study, but to study smartly. And let's take a reference, few examples, what have been 2019 to 2023, there were some list of questions. These are from mains that were asked, which are based on the scenarios like all the fundamental rights, you can say. In 2023, the Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for progressive society, illustrated with special reference to the expanding horizons of right to life and personal liberty. If you will notice what they're trying to ask you, they are not just asking you about the right to life and personal liberty, Article 21. They are not asking that. What they're asking, how the right to life and personal liberty is expanding these days. So on what basis they are saying this? On the basis of the news. So maybe there were some topics that were in news at that time, and on the basis of that, they are saying there are more things that have added in Article 21, right to life and personal liberty. And that's how the horizon of fundamental right, Article 21, expanded. So this is the way they can ask you questions. Like, let's say one of the article is in news regarding the fundamental right. They can just ask you to shed some light on it, to critically analyze it, and so on. In the year 2022, there was one question: right of movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. So as I said, everybody can go anywhere, wherever they want within India. They can move, even outside India they can go. But there were two different articles that are protecting these things. You might know there were some areas that are tribal areas and scheduled areas which are restricted, from where going the people's residence or movement is restricted in order to ensure their special existence, I can say. So this is the article, this is the question related with that. In 2017, there was one more question: examine the scope of fundamental right in the light of latest judgment of the Supreme Court on the right to privacy. So as you can see, all these questions are not based on your book. Definitely it is based on the book, but they have some sort of dynamism to it. They have some sort of current affairs niche masala to it. Okay, so this is how they ask questions to you guys. And if you prepare the way I just try to explain you, it will be helpful to you to understand the trend and to enhance your answer. So this is it. As we are not able to cover all the fundamental rights today, because fundamental rights is a very, very vast topic to discuss and cover, I will just shed a light on few of the fundamental rights, and then we are good to wrap up. So, right to freedom. Just before we discuss that, there was a right to freedom, freedom of speech, movement, profession, assembly, so on. We can speak whatever we want with reasonable restriction. We cannot disrespect anyone, or we cannot harm the dignity of any individual, which is the latest case we have seen. Stand-up comedian in stand-up comedian joke case. Protection of life and personal liberty, Article 21. Protection against arbitrary arrest and detention. Like, nobody can just put us in and detain us. Yeah. So even the detainee has some rights. He has right to consult. He has right to inform. He has right to produce before the magistrate within 24 hours of arrest. So every individual, every citizen, I will say, has some sort of rights given by right to freedom. Right against exploitation. No human trafficking and no forced labor. You might know, you might have heard in history that there were a term called begar, and very the peasants, generally the worker section, used to have a forced labor for which they are not going to pay a single penny, and that was abolished. You cannot pay without money. You cannot work without money. So if somebody is paying you, that's the only thing when you are working for them. Prohibition of human trafficking and forced labor. No human trafficking. So no human trafficking is allowed. No child trafficking. No women trafficking is allowed. Next is prohibition of child labor. Whoever is below the age of 14 years is not going to have a employment, but not all the employment, because you see many small actors, kids are working in the film industry, advertisement industry, and so on. So they are prohibited to work in the hazardous factors that are also mentioned in the separate law. Right to freedom of religion. As I mentioned previously, there were a bunch of articles from Article 25 to Article 28, who is specifically related with the fundamental rights of religion, not just the individual religious right, but also the institutional religious right. So in the first is freedom of conscience and religion. What is freedom of conscience and religion? So we can concise, we can profess, we can practice, we can propagate our religion. It doesn't mean we can we can take somebody and forcefully convert his religion. So forcible conversion of religion is not allowed. But yes, if we believe in some religion, we have faith in some religion, we can definitely profess it. We can practice it at our own personally, because religion is a personal sphere, not a public sphere. And you can propagate it. Propagate in the sense you can propagate the good ideas or good values that that particular religion provides. Definitely you can propagate it. Freedom to manage religious affairs. So as I mentioned, history, India is a religious country and there were so many religions in India. Every religious institution can manage their religious affairs. So let's say there is Dargah, like Hindu person is not there going to manage their religious affairs. So if it's the Dargah, probably a person who is belonging to Muslim is going to manage their particular religious affairs. A temple is going to be managed by the Hindu religious individual, and so on. So every religious institution can manage their religious affairs on their own. Freedom from praxis for religious promotion. Our India is not a India does not have any state religion. So like let's say example of Pakistan. Pakistan officially declared that Islam is their state religion. India is not the same case. So India does not have any state religion of its own, and that's why we used to say Vasudha Kutumbakam, and secular country we have all the religions, we respect everyone, each and everyone's religions and so on. But let's say one day state come and he says like you have to pay a tax for the development of that particular religion. So let's say Hindu is a majority, and then for the promotion of Hindu religion you have to give the state XYZ tax. This is not going to happen. State cannot charge for the promotion of particular religion any tax on an individual. This is not going to happen because we have a fundamental right for it. For the promotion of individual religion, state cannot levy a charge on a citizen. Freedom from religious instruction in state-funded institution. There can be many kind of institutions: state-funded, own-funded, and state-managed, and so on. So all the religious instructions are banned from the private institution. Like if it's a completely state-owned, then there are some restrictions on religious instruction. It is not mandatory that you have to follow some religious instructions in that particular institution. So these are some fundamental rights related to religion given by Article 25 to Article 28. The fifth is cultural and educational rights. Culture, which we believe as Indians, we are having a vast culture and so on. So Article 29 talk about culture, language of minorities, not specifically minorities, but a section of citizens. What Article 29 says, a section of citizens can protect protect their culture, language, and so on. So any section of citizen can protect their culture and language. South Indian people can protect their culture, whatever the way of their living is, and so on. Right of minorities to establish and administer educational institution. Article 30. Article 30 talks about the minorities educational institution. In minority educational institution, there are children from the minority itself. So this kind of educational institution has given the right that they can manage the religious instruction, who is the teacher, who is going to be the staff, what will be going to be the fee structure, what will be the curriculum, the course, and so on. They can manage on their own. This is the Article 30 of this Constitution. Right to constitutional remedies. Article 32. The question is, Constitution has given this whole chapter, whole part 3 of the Constitution, which talks about the fundamental right. But what if, or who will ensure that these fundamental rights are followed, or everybody is following and abide by the fundamental rights? What if somebody disfollow or disobey the fundamental rights? Then what? So we have a exclusive fundamental right to constitutional remedies, Article 32, and it says it's the duty of the Supreme Court, it's the duty of the High Court, the court system, the judiciary of the India, to protect and prevent the fundamental rights of the citizen. Neither the legislature and nobody else can do any acts or do certain things or actions, take any actions which is derogatory to the fundamental rights of the citizen. Such law which is passed by the parliament, which is disobeying the fundamental rights of citizens, can be considered as unconstitutional and void. So this is the Article 32, which enforces the duty on the judiciary, on the Supreme Court and the High Court to protect the fundamental right of the citizens. There are different type of writs which can be used by the Supreme Court, like habeas corpus, mandamus, certiorari, quo warranto, and so on. What are these things? Like maybe this is something which is very confusing for you as of now, but this is something we can discuss really detail in a separate topic, because fundamental rights is itself a very vast topic to discuss. And this is all about the fundamental rights. Broadly, we categorize it into 6 types. And yeah, this is it. Now, if you want to enroll in Aakar Foundation for your different courses for UPSC preparation, once first, second, and third year foundation course, then you can just contact them out. And there is one more MPSC combined exam. For there also they provided a course. You can just contact them on their official website or the contact they have given. That's it from my side. Thank you so much all of you for the session today.